Hi, I'm Jason Sullivan of Rathbone Group, and this is on subrogation. If you have any subrogation topics you'd like us to cover, please email us at video@rathbonegroup.com. This video is on spoliation of evidence. What happens when the evidence you need to prove your case is suddenly gone or has disappeared, and you think maybe the other party or a third party had something to do with it? That's where spoliation comes in. When you're proving your subrogation claim, whatever it might be, if it's a product defect case or something else where you need physical evidence to be inspected and to put forth that evidence to the jury or the court to prove your case, and you lose that evidence or that evidence is gone and no longer available to you, what do you do? And is your case lost without any hope? The courts and the states are really divided on this, and there are a lot of different opinions. Some states do allow an independent cause of action for spoiled evidence or lost evidence. Other states say that there's no cause of action at all. The states that say there's no cause of action are trying to avoid endless litigation that drags on and on. If a party loses their underlying suit and then they sue parties that they believe if they had evidence or provided the evidence, they could have proved their case, and it just cascades on, and the courts are trying to avoid that. However, states that do allow a cause of action for spoliation of evidence are trying to make sure that parties who are damaged are compensated and can prove their case. There's also a flip side on the spoliation. It's not just plaintiffs who maybe don't have evidence available. Defendants may have evidence, or there may be evidence available to a defendant that could help exonerate them, show that they're not liable and don't owe any damages. If for some reason the plaintiff or a third party has lost or destroyed that evidence, then a defendant would also have a spoliation claim. So it's not a one-sided theory or cause of action. But it is important to know that the states all handle this very differently. And in some states, there's no cause of action, and in others, there are. And when we're talking about a cause of action, we are talking about a separate suit. There's a separate claim against a party. And that could be first party, it could be a party to the litigation already. A plaintiff sues the defendant, and the defendant disposed of the vehicle that's at issue, and the plaintiff really needed that vehicle. And so that would be a cause of action directly against the defendant. But it could be a third party. Let's say you're a plaintiff and you're hit by another driver and that vehicle goes to the impound lot. Now, the impound lot isn't necessarily a party to your cause of action. They weren't involved in the motor vehicle collision. But if that impound lot did destroy the vehicle, then there could be a cause of action for spoliation against that third party in states where it's recognized. And the elements of a spoliation claim are: you need to have pending or probable litigation involving the plaintiff. So the person bringing the spoliation claim either has to have pending litigation or there's probable litigation. The defendant, the person who destroyed or lost the evidence, needs to have knowledge of that pending or probable litigation. You need willful or even negligent, in some states, destruction of that evidence. You need a disruption of the plaintiff's case. And this is something that's very important, because just because the evidence is gone, if the evidence wouldn't have helped the plaintiff or the defendant, then there's no real harm in that, and the court's not going to allow pursuit of a spoliation claim. But if there is disruption of the plaintiff's case and then damages, so the case was disrupted and they were unable then to collect. So damage to the plaintiff due to defendant's action is also required. And that really matches up with a negligence cause of action. You have a duty, which would be a plaintiff with a cause of action, and a defendant with knowledge of that needs to preserve the evidence. A failure to meet that would be destruction of the evidence. And then causation, which harmed the plaintiff's case, and the damages are the inability to prosecute their case. So in states where it is allowed, that would be a spoliation claim. That's a separate claim. Now, if you're in a state where there's not a separate cause of action for spoliation, what happens if a party to the lawsuit destroys or negligently gets rid of evidence? And in this case, there's usually discovery sanctions. So it's not a separate cause of action, but the court will have the power and the authority to make a decision in relation to the case to basically set the parties right. The concepts that the court is trying to carry out are: they want parties to not be incentivized to destroy evidence. If you were allowed to destroy evidence without any consequence or repercussion, well, a party that was in possession of evidence that was bad for their case, would they just get rid of it? And then no one would be able to prove the case against them. So that's why the discovery sanctions or sanctions by the court, even if there's no separate cause of action, are important, because we don't want parties to destroy evidence that's bad for their case. We also want to be able to make sure that injured parties are able to be compensated. So courts want to make sure that just because some evidence was lost or destroyed, that the party is now no longer going to be able to be made whole or compensated for their loss. They want to preserve those causes of action. In these spoliation sanction cases, then, the court's going to look at how culpable is the party, how bad was their conduct in getting rid of or destroying the evidence. If it was negligent, inadvertent, and it was not intentional, the court's less likely to promote or impose a sanction that's very strong against that party. However, if a party knows that they should preserve this, and then they intentionally, with knowledge that they were going to get rid of this evidence, and they had bad intent or bad will, they were trying to improve their case or hide the ball from other parties, the court's going to have the authority to be stronger in the sanctions against the party that destroyed that evidence. The court's also going to really want to look at how important is the evidence to the case. If it's not that important, if it isn't a necessary thing, then the court is probably not going to impose a very serious sanction. But these sanctions range from the most serious of, it could be a dismissal of the case or holding judgment against a party without even trying the facts. But more likely, it is going to be something that could be like a presumption of a fact to be true. So the court's going to say, well, we can't inspect that evidence. The plaintiff didn't have the ability to look at it. They didn't have the ability to put that evidence before the court. So we're just going to assume that had they been able to, that evidence would have been bad for the defendant. Again, that's a pretty strong sanction, and so a lot of courts won't go that far. But they still may award attorney fees or costs in that sanction, where if a party spent a lot of time trying to get a hold of the evidence, and then they find out, well, that had been destroyed and the other party was hiding the ball, well, in that case, the court might award attorney fees. So if you do have a subrogation case and you feel like there's particular evidence that needed to be protected, what's the first thing you should do? Well, make sure the parties that have the evidence or could have the evidence know that this is going to be subject to litigation if we can't get this resolved, and therefore that evidence needs to be preserved. If you're in a state that allows that separate cause of action, well, now you, as the plaintiff, will have a cause of action or a possible cause of action if it's not already pending, and the defendant or the party in possession of that evidence will be on notice that we might be filing suit on this and there's a dispute and that needs to be preserved. If you do that, now you can get to the additional hurdles of looking at whether or not that evidence was properly preserved, and if they destroyed it or got rid of it, was it negligent or intentional, so that you can meet whatever requirement is required for that state to create that cause of action. So 1, you're going to want to put parties on notice, and then 2, you're going to want to be very diligent about inspections. There's a lot of cases on records where a plaintiff will file suit out of a motor vehicle collision and the vehicle should have been held. Well, things take time, and when they go to that inspection lot or that impound lot to go look at the vehicle 18 months, 2 years, sometimes 2.5 years after the accident, well, they find out that that is gone. An important thing to know is that the statute of limitations for these causes of actions is very different depending upon how the state's going to interpret it. Some look at it at the date of destruction. Some look at it when the plaintiff found out it was destroyed. Others push it back further to when the cause of action arises when you don't win your case. The important thing to know for all of these are you need to be very diligent. So put parties on notice, diligently pursue the claim, and keep tabs on where all that evidence is. And then that should avail you to, if for some reason that evidence is lost at a later date, if the state has an independent cause of action, you may be able to use that. If it doesn't, hopefully the party that disposed of it is a party to the lawsuit, and you can ask the court to impose some kind of sanction. And again, the court isn't just going to grant judgment against the party that got rid of it. They're going to look at how important was the evidence, how much was the harm, and they're going to try and craft a penalty to prevent parties from doing that in the future, to get the plaintiff made whole and in the right spot as though that evidence wasn't lost, but they're not going to just grant judgment. If you have any questions on spoliation or any other topic, please feel free to contact us. For On Subrogation and Rathbone Group, I'm Jason Sullivan, and that's the long and short of it.